Some more post office scandal news for you, because there's a case this week. Now, it's not one of those sort of big headline grabbing cases, it's more of interest to lawyers, but it does have some important implications. And the issue at stake was, when the sub-postmasters receive a compensation, some of them had been made bankrupt. So does that money just go into the bankruptcy to pay off their creditors? Now, I'll cut to the chase and I can say it's been decided that no, it doesn't, for various reasons. Some sort of policy reasons and some just legal. But first of all, I should probably explain briefly what bankruptcy is, what the compensation scheme was, and why they've made that decision. So what's bankruptcy? Personal bankruptcy is when you can no longer pay your debts when they fall due. And if you get to that situation, one of your creditors, assuming the sum is over a certain amount, it used to be £750, but now it's £5,000. I think it is. I'll put that in the comments. If that debt arises, then your creditor, or a number of your creditors, because they can collate the debts to reach that amount, they can petition for your bankruptcy. So they file a petition which basically says, you need to pay this, otherwise you will be made bankrupt. There are alternatives to bankruptcy. You can do what's called IVAs, individual voluntary arrangements, where instead of actually going down the legal route, you just agree with your creditors a scheme to pay off the debts. And all your creditors have a vote, and the vote is proportional based on how much you actually owe them. One of my friends was actually one of the first people to get an IVA, and it worked out really well for him because he was being chased by loads of people, including the revenue, but luckily the revenue had more than half the debt, so they just basically controlled what happened. So they voted for a scheme that basically the revenue got all their money and everybody else just got shafted. So he was quite happy with that scheme. But let's say you can't come to one of these arrangements, then it goes to court. And if you are found to be bankrupt, in other words, there is no way of paying these debts or offering security on the debts, because that is a defence to bankruptcy, that you can securitise the debts. So say, for instance, you've got equity in your house, you can agree to have a charge put over your house, which is, if you ever sell that house, then your creditors get first dibs on the money. But if you can't do that, then you are declared bankrupt, and a trustee in bankruptcy is appointed. And that's somebody, usually like an accountant or something like that, or an insolvency practitioner, and they just run your affairs. They come in, they take over everything, and they look at all your assets, all your income and potential income, and all your creditors, and they have a look at seeing whether there's any way that you can pay your creditors off, even if it's a percentage, 10 pence in the pound, or something like that. But what can they chase? Well, pretty much they can chase any of your personal assets. They can also, go after your wages and your income. They can also, they take over any court cases you have. So say, for instance, you're suing somebody over a debt or something like that. You can only bring that claim with the consent of the trustee. And the trustee can actually run that claim and say, right, any money recovered, we're just going to use to pay off your creditors. But not all cases fall within bankruptcy. It's usually got to be something financial. So say, for instance, personal injury. You lose the use of a limb or something like that and you get compensation. That money cannot be used in a bankruptcy because it's not really an income, is it? It's compensating you for a loss, and it's not like you could pay your creditors off by saying, okay, I'll chop my arm off and give it to you. I'm sure quite a few of them would accept that, or at least seem to. Same with defamation, actually, because defamation is a personal action. There's a very noisy dog and some kids having a party in the vicarage. I might go around there afterwards and see if I can join in, because that dog sounds very invested in being a dog. So those sorts of court cases where it's not financial, it's actually compensating you for a personal harm, then that isn't recoverable. But what was the position with the post office? Because all of a sudden they've just been given money to compensate them. But is that money for financial loss, or is that money for the personal harm and suffering? Is it compensation in the sort of personal injury defamation sense, or is it damages in the financial remedies sense. Because if it's damages in the financial remedies sense, then it all goes off to pay the creditors. Now, interestingly, because a lot of people, the Postmasters, when this all hit, then, all of a sudden they lost their income, they racked up loads of debts. Quite a lot were with, sort of innocent third parties. Well, I say innocent, but they couldn't, for instance, pay off loans or, mortgages or things like that. But one of the creditors, of course, was the post office, because they were claiming all this money was stolen. So they're going, oh, we want our money back. Now, it's fair to say in this litigation, the post office disavowed any claim and said, look, we are aware of the public sentiment at the moment. We won't chase these people. But this was like a test case, and basically some trustees in bankruptcy and some of the postmasters agreed to be the sort of test case to determine this. Because the trustees said, look, it's not like we're out to, ruin these people any further, but under the law our duty is to the creditors, so we'd like some court guidance as to what to do. We'd be quite happy not to give it to the creditors, but we'd be in breach of our duties if we do that without the court approving it. So it was done on a few grounds. I mean, one was a lot of these people what were called discharged bankrupts, because when you're made bankrupt, you're only made bankrupt for a certain amount of time, usually 12 months. Somebody pointed out and said only in the UK would an act that makes it easier for people and companies to go insolvent be called the Enterprise Act. But under the Enterprise Act, it's only 12 months. In some jurisdictions, it's like can be up to 12 years. So you would actually get people, especially like coming over from Ireland, getting made bankrupt in the UK because then they're only bankrupt for 12 months, but also that applied back in Ireland. So you did get a bit of forum shopping in bankruptcy. So some of these people were by now what we call discharged bankrupts. Although theoretically, even if you're discharged, if you sort of win the football pools, after your discharge and there's still creditors outstanding, then you can sort of, the creditors can chase after that. Some debts are never extinguishable in bankruptcy as well. Student loans, for instance. You can never discharge a student loan in bankruptcy. So, that sticks with you for the rest of your life. But in this particular case, they said, okay, well, we can deal with this very simply. We'll say that anybody who's a discharged bankrupt, it's now too late to go after it. But what the court said is, we're going to regard this money as if it was compensation for personal injury for her. So it's a personal thing, so it's not recoverable in bankruptcy, so people can keep their compensation. So that's good news. But the case also reveals some other things, and I'd meant to speak about this before, because the test cases, when the people sued the post office, as you know, the post office really went all guns blazing, and basically we will ruin these people for coming after us. They played really, really dirty, and a lot of people are going to be in trouble for that. But they also said, we want security for costs. If you're suing us and we win, then you owe us our costs. But who's going to pay our costs? It's outrageous. So you shouldn't be allowed to sue us unless you can cover that. So the postmasters were able to obtain what we call after the event insurance. An insurer said, okay, we will cover the cost of you bringing this claim. But what did they want in return? Because it used to be that you could get insurance, and then if you were successful, the insurers would recover their costs from the other side with an uplift, for the premium and things. So that was how they get their bit of money. But in this case, they did what we call a damages-based agreement. They said, okay, we'll take a percentage of your whatever we recover. And the percentage they took was 75%. So people were only left with 25% of it. Now, there was a case after that where the court decided that people who were, of course, involved in litigation have to be regulated. Otherwise, any agreements aren't enforceable. The contract is void for illegality, as we say, because they had no right to do that. And the courts decided that insurers were, quote, involved in litigation. Now, the insurers' arguments were, well, no, we're not. We just lend people money. If you borrowed money off your friends, for instance, to fund a court case, the courts are quite clear that mere funders are not involved in litigation. So say, for instance, you just chip in for a good cause to fund somebody, then if they lose, the other side cannot chase you for the money. I mean, there is a thing called the Section 51 order that does allow the court to make a costs order against anybody, even if they're not a party to the case. And they will do that if they think people are involved in what we call champity and maintenance. In other words, funding a court case for their own personal benefit, not just because they think it's a good case. And that could be they're getting something financially out of it, Or it could even be they just don't like the other party and they just want to cause trouble for them. So yeah, there is this rule where you can actually enforce against third parties. And that's what they decided in this case. They said, actually, insurers are involved in litigation, they're not regulated, therefore the contract's void, so they can't recover any of the percentage of the damages, which is good news for the sort of parties who were funded, but not very good news for insurance companies, because they said, well, what's the incentive for us to even fund this litigation? And now, with the absence of legal aid, insurance is one of the major ways people, fund litigation. So all the insurers now are trying to work out some sort of new package that satisfies the law, but does actually allow them to recover either an uplift on the cost or a percentage of the damages. And I'm following that quite closely because obviously, as somebody who does a lot of civil litigation, including defamation, insurance is a big thing for us. So we're hoping that will be resolved soon. I mean, the insurers obviously want it resolved. They're not just sort of, taking their ball home and going, well, we won't do it anymore, because obviously that's their entire business model. So, they want to be able to continue to do this. But yeah, so that's the position. Like I say, good news for the Postmasters. But I just thought you might find it interesting, or at least vaguely interesting, or vaguely useful, and vaguely accurate. So there you go. If you did, please consider liking, sharing, subscribing. Where am I today? I'm just up at St Clement again, because it's been siling it down all day. I thought I was going to have to just sit in my truck and do this video, but then I'd just be another sort of like ranty, shaven-headed guy talking to a camera in his truck, which is usually like a prelude to an insurrection or something. So I'm quite glad I didn't have to do that. But it's so lovely here. I think I might eat some more crisps, drink some more coffee, because I've just got some crisps and coffee off camera, and have a little saunter around there and see what all the noise is about.